So this is the timeline,
All right.
and this is where you were arrested.
Okay.
All right. First thing you have in court is going to be your initial appearance. At the initial appearance, the judge is going to make sure he understands that you know what you're charged with, and find out if you're going to get a lawyer or not. If you can't afford a lawyer, they'll appoint the public defender to represent you. Then they're going to reset your case to DUI court, and in DUI court, there you have what is called a preliminary hearing. You're entitled to a preliminary hearing. Anybody that is arrested, charged with offense, has a right to a preliminary hearing. And what that means is the state or the prosecutors with their witnesses, usually a police officer, is going to have to convince the general sessions court judge that there's probable cause. All they have to do is show this more likely than not that you committed the offense. They don't have to prove you guilty beyond a reasonable doubt.
Okay.
If they can't do that, then the case is thrown out. So preliminary hearings are very important because the police officer comes in, he's under oath, he's interrogated by me. First the prosecutor will ask him questions, then I get up there and I get to ask him questions, and anything he says, it's under oath, it's recorded, and he's stuck with it.
Exactly.
So if he contradicts himself or we can use it against him later on, that's what we'll do. Now if the judge decides that there's probable cause, then the case gets bound over to a grand jury. These are just a group of people that sit in a room and make a decision on whether you should continue to be charged with the offense. You're not allowed to go there. I'm not allowed to go there. But usually, if your case goes into the grand jury, 3 to 4 months later, it's going to come out in criminal court. And that's where you have a right to a trial. You have an absolute right to a trial in criminal court. And you'd show up for an arraignment, then maybe we'd set it for a motion day. Maybe we can work it out. All the time we're trying to get the best result we can, get some sort of offer that you're
Pleased with.
And if we do that, then we don't have to go to trial. So normally what I usually do is I charge for that much. I don't charge for a trial because some attorneys will charge for a trial knowing darn well you're probably not going to go to trial. Yeah.
Exactly.
But if we do decide that a trial is the best thing we need, that's going to be a year from now before we have to make that decision. And then there would be another fee for the trial.
Exactly.
Okay?
Yes, sir.
Okay. Thank you, sir.
Thank you.